A judge in Kankakee County ruled that a part of the Safety Act is unconstitutional. Now, with only 2 days before cash bail was set to be eliminated, counties are trying to figure out their next moves. That is the top story at 6. This ruling only applies directly to the counties in the case. The judge refused to issue an injunction, which would have applied to every county. But now there's a lot of confusion. Here's what it comes down to. Until the Supreme Court issues a ruling, judges in each county can decide how they want to proceed when it comes to the elimination of cash bail. Illinois Capitol Bureau Chief Kankakee has more.
Nearly 2/3 of counties will not eliminate cash bail on January 1st. A Kankakee County judge ruled in favor of state's attorneys, saying cash bail is a constitutional right in Illinois. It gives those counties the ammo they need to sidestep the new law, for now. Kankakee County State's Attorney Jim Rowe, a Democrat who led the case for state's attorneys, said in a statement, quote, "The people of Illinois deserve better than that, and today's verdict condemns the act for exactly what it is, unconstitutional." The state is appealing to the Illinois Supreme Court, and that ruling will be the final say on the matter. Supporters of the Safety Act, including the governor and the attorney general, are confident the Supreme Court will overturn this ruling.
Well, I mean, it's frustrating, but ultimately it's a setback that we believe will be rectified in the Supreme Court.
But the Supreme Court's ruling could come down well after the start of the new year. Until then, counties that aren't involved in the lawsuit are in limbo. They can either eliminate cash bail and move forward as scheduled, or they can choose to delay the implementation until after the court gives the final say.
It would be in not only the plaintiffs and the defendants' best interest, but also the people of the state of Illinois to begin this process over again.
The Supreme Court could also take preemptive action and give the entire state directions on how to proceed before the new ruling comes down. But so far, they have not given that order.
That was Kankakee reporting. The Illinois Supreme Court Implementation Task Force, which prioritize and implement the recommendations of the Supreme Court, has already interpreted the part of the Constitution that addresses bail, and their interpretation did not include that it has to include cash bail. Well, looking into how this impacts officers, some counties across the state are looking into how they will enforce it. Sheriffs from across central Illinois say until the Supreme Court weighs in on the ruling, they won't see a change. Macon and Coles County are only 2 of the 60-plus counties involved in the suit. The Macon County Sheriff says they've been preparing for the Pretrial Fairness Act for weeks. Meanwhile, the sheriff in Coles County says he's working with his staff to make sure they have a plan in place if cash bail is eliminated.
It looks like going forward, we will continue to operate the way that we have up until this point, but I want to work with my senior administrators to still have a plan in place if something happens where this does wind up being implemented.
The Champaign County Sheriff says his county is not a part of the lawsuit, so they're moving forward as if it did not happen. He's also open-minded to changes and interested to see how it all turns out.